everybody. Thank you ever so much for joining us today for our New South Wales Council edition of our HR Breakfast Club. My name is Rachel Archer and I'm the Client Services Manager within the Employment Law and Investigations Group at BAL Lawyers. Throughout today's webinar, if you're able to type any questions that you may have in our Q&A box, which is the icon at the bottom of the screen, we will try to get through your questions throughout the presentation and hopefully at the end as well. Our guest speaker today, who I'm delighted to introduce, is Gabrielle Sullivan, who is our Director and New South Wales Accredited Specialist in Employment Law and Investigations. Gabrielle, I can see your camera's on, so I know that you're there. And over to you.
Terrific. Thank you, Rachel. Well, welcome everybody and good afternoon. As Rachel said, my name's Gabrielle. I'm the director here at Bradley Allen Love in Canberra, and I'm absolutely delighted to have you all on board. We have quite a number of councils. I think Rachel introduced a couple, but we've got councils from frankly, a lot of New South Wales. So plenty of people from central New South Wales, way out west, down the coast, and plenty in between. So welcome aboard. If I haven't met you in person, I'm absolutely looking to do that one fine day. We're talking about bullying, and I was very intrigued to see that in the new 2020 Local Government State Award, the New South Wales Government has decided to, or the award parties have decided that they want to think about a bullying jurisdiction for New South Wales. So, as I said, we're in Canberra. We do a lot of work in the Commonwealth bullying jurisdiction. I feel like we've absolutely got a lot to offer in terms of insights that we've gained from that experience. It looks very much like New South Wales is heading down that route. So I thought we would take this opportunity to step you through it. Because of course, bullying is a pretty large part of the work that we all do. What are we going to try and do in this session? We want to, I really want to give you a practical overview of the Local Government State Award 2020, which of course, as we know, started July this year. The provisions regarding bullying. Now, there were actually loads of changes that came in that the 2020 award, and we might have another session down the track as to plenty of the other changes. But the bullying provisions were intriguing to me, and so I thought, well, I'd run this session. What are we going to talk about? Just a quick starting point, you know, why is bullying a problem, and generally how does HR go about it? I thought it might be helpful for us to just put our work in context there. Then I want to whiz us through what the New South Wales Award actually says. I want to show you how the Commonwealth Fair Work Act tackles the same bullying problem. I'm going to highlight the similarities and the differences. We've had a Commonwealth jurisdiction since 2012, I think. So there's about 8 years of experience there, and they're very similar. The regimes are very similar, so there's a lot that you can learn by knowing what happened in the federal jurisdiction. And lastly, I want to end up by talking about, just briefly about, at a really practical level that I assume most of you are managing on the ground, how might HR managers effectively approach bullying complaints while we're waiting for this great new scheme to come into legislative fruition? What do we do right now? I'm going to give you some practical tips because, as I said, we here advise plenty of people in the Commonwealth Public Service and the agencies. We advise at territory level, and we also advise, scores of New South Wales local councils. So we feel like we do a fair bit of this. I think we're well placed to share the benefit of that those insights. So that's what we're going to do. As I said, we'll take a big Q&A at the end. I'll take a break in the middle to take the questions as well. So this is just a really high level, there's nothing particularly mind-blowing here, but why is bullying a problem? Well, it reduces morale, does it not? Quite often, either the bully or the vexatious complainant stay in the employee, and the good people leave. That's not good HR. It can lead to reduced productivity, absenteeism, workers' comp claims, discrimination claims, unfair dismissal claims, the whole box and dice. Bullying, of course, is also a WHS risk, and it has to be managed in accordance with your established WHS frameworks. So it hits a lot of HR buttons, and it costs a lot to sort out in terms of naked dollars and angst and effort by HR personnel such as yourself. So it's a big deal, and I'm not telling you anything you don't already know there. How do we routinely tackle it? Again, there's nothing new to you here. I would take, essentially, we sort of have a four-step approach to tackling bullying, and this is not confined to New South Wales local government at all. This is how we do it in the private sector as well as most public sectors in Australia. Essentially, you have a policy that sets out what respectful behaviour is, tells you how and when to report problems, and it tells you what the consequences are for non-compliance. Now, you folks in New South Wales local government have the benefit of a code of conduct that effectively is that policy. It's uniform across the state, and so you don't have to worry about drafting it as such. So you've got a policy in place. HR will then make sure that people know about that policy, right? Where is it? It's on the internet, it's easily available. We train our staff in it, and we promote it in various ways. At a sort of New South Wales local council level, annual sort of code of conduct refresher type training is a pretty good standard to be aiming for if you're not doing that. Make sure your people, you've got records to say who attended. It's always the person who didn't sign the training sheet is the one that is on the wrong end of these things. You have a policy, you train your people in it, and then when instances are reported, you act on it. You act on it reasonably, you act proportionately, and you act in accordance with what your policy says. And finally, you tackle bullying by modelling respectful behaviours. And ideally that happens from the top down. It's a culture issue, how we do things around here. Ideally, HR gets upstream, as it were, and regarding worker wellbeing and those sort of much more lofty concepts that might well prevent bullying from happening in the first place. So that's your thumbnail sketch of how HR tackles it across the country to date. So what I wanted to do now was talk about what the New South Wales Award 2020 award actually says. Now, just checking my slides. Oh, I see. We've got somebody's given me some drop-down slides. Okay, we'll go with it. So, what is the? I want to quickly show you now what does the New South Wales 2020 award say, and of course, I'm referring to clause 39 of the 2020 award if you haven't already seen it. It says a few things. It says the parties to the award are committed to eliminating bullying in the workplace, and they're committed to pursuing legislative change to give the Industrial Relations Commission of New South Wales the power to make any order it considers appropriate, other than an order requiring payment of a pecuniary penalty amount, to prevent workers from being bullied at work. So I'm going to unpack that, don't worry, but essentially what it is a statement of commitment that says in the award that the parties to the award will commit to pursuing legislative change to get us a stop bullying jurisdiction up in New South Wales, because you don't have one at the moment. As I said, the Commonwealth certainly does. Queensland, I think, has adopted one for local government. So it's kind of the go. So New South Wales are getting on board. It's not in force yet, right? It's a commitment to frankly work towards it. Interestingly, though, the parameters around what that legislative change are going to look like are clear there at sub B there. You can see the idea is that there will be a external arbitrator, as it were, so it'll be the Industrial Relations Commission. It goes beyond internal decision making. So it'll be the decision maker will be the Industrial Relations Commission. It will have power to make any order it considers appropriate, other than an order requiring payment of a pecuniary penalty amount, I'll unpack that amount, to prevent workers from being bullied at work. These terms are very familiar to those of us practicing in other jurisdictions, and I'm going to tell you what they mean, or what they've been held to mean in those jurisdictions, so that you can sort of know what you're going to get yourself into when this scheme gets up. So that's what the parties have committed to. That's what Clause 39 says. It says a couple of other things as well. It says, has a go at, it says what bullying is, and the good news is they were sensible enough to copy the definition of bullying straight out of your Code of Conduct, your 2018 Code of Conduct. So it should be, the definition of bullying should be something that it's at least familiar to you. And certainly it's familiar to me because, as I said, it is very similar, not entirely similar, but very similar to what the definition of bullying is at a federal level. I might say I've been practicing for quite some time now, and I was around well before we even had a definition of bullying. And it's terrific to have a solid definition. We've only had it since 2012. Prior to that, there was all sorts of arguments about what bullying actually meant, and you know, here's school kids and whatnot talking about school yards all the time. You know, bully this, bully that. What does it mean? We need to know. Good news is the Commonwealth has set the standard, and the New South Wales Model Code of Conduct has effectively followed suit, and now in the award they're adopting the same definition, and that is this, that bullying shall mean conduct at work where a person or a group of people repeatedly act unreasonably towards an employee or a group of employees, and that behaviour creates a risk to health and safety. Just trying to work out how on earth to drop that down. Right. So there's really a couple of elements there. Repeatedly acting unreasonably towards an employee, that creates a risk to health and safety. As I said, I'm going to tell you what that means. Your Clause 39 of the award goes a bit further than the federal legislation and actually lists some examples there of what bullying is. Again, they're straight out of your Code of Conduct, so there shouldn't be anything new there. They're the usual suspects, the kinds of things that we would routinely consider may well amount to bullying, depending on particular circumstances. You know, aggressive, threatening, intimidating conduct, belittling, humiliating comments, spreading rumours, practical jokes, excluded from work-related events, and so on and so forth. So, nothing particularly new there as such. The definition of bullying in the award, it has stuck with the traditional the Commonwealth formula and the formula that's reflected in your Code of Conduct, that bullying is not reasonable management action carried out in a reasonable manner. Sorry. Right. Sorry. So it says what bullying is: repeated unreasonable behaviour creates a risk to health and safety. That is not reasonable management action carried out in a reasonable manner. Again, that phrase should be familiar to you. I'm going to explain what exactly that means, at least as far as the Commonwealth jurisdiction is concerned. Probably should at least appreciate for the moment that the phrase reasonable management action carried out in a reasonable manner has three limbs. Has to be management action, has to be reasonable management action, has to be carried out in a reasonable manner. That's the same as what's happening in Commonwealth, so I'll explain that. Your award does give a list of, a non-exhaustive list of examples of what reasonable management action consists of. Again, this is straight out of the Code of Conduct, so there shouldn't be anything unusual there. The usual kind of things: performance management practice, disciplinary action for misconduct, telling employees that their performance is not appropriate, their performance or their conduct is not appropriate. These kinds of things are conceptually reasonable management action, provided they're done in a reasonable way. Then they will not be bullying. I'm going to unpack that shortly. So, right. So that's what your award does. Just struggling with this. Okay. So the award says that the parties are committed to legislative change, so bringing a new bullying regime, defines what bullying is in terms that we're all familiar with, and then lastly, it sets out what the process is for dealing with bullying complaints while we're awaiting that new legislative scheme. And what it specifically says is this: where bullying behaviour is alleged, the grievance and dispute procedures of Clause 36 of the award will apply. You will be familiar with Clause 36, I am sure. I've just stepped it out there. Sorry, it's a bit of an overwhelming PowerPoint, but I figured you would have heard of Section 36 before. How do we resolve grievances and disputes in New South Wales local councils? And just to be clear, these are employee grievances and disputes, because we're talking about the award, not talking about councillors or ratepayers or whatnot. What's the process? Well, party's entitled to a union rep. You notify the supervisor of the grievance and the remedy that you're seeking. A meeting's held between the supervisor and the aggrieved employee to discuss the problem within 2 days of being notified. If it's unresolved, it gets escalated in accordance with the usual process, and the buck stops with the general manager. Ultimately, that is the industrial dispute resolution clause that can ultimately find voice in the Industrial Relations Commission as an industrial dispute. I don't know that it's ever been used for bullying purposes, this particular the industrial dispute jurisdiction. It's a bit of an odd bedfellow in some respects to put bullying through the grievance and dispute resolution procedures, and certainly in the private sector we would suggest they be separated. There is overlaps in it. It can happen. Commonwealth Public Service does it slightly differently, but regardless, that's what's happening for the minute. I'm going to tell you how to navigate that process sensibly. Obviously, one of the questions you might want to ask is, well, hang on, how does that fit in with any sort of code of conduct process or disciplinary procedures, and how's it going to fit in with this new legislative scheme that it says there at the statement of commitment we're going to get. So I will talk to that, but that's what the New South Wales bullying provisions local council are as we speak. So let's move on a little bit. So I've talked it. So that's what New South Wales got. Like I said, it's very similar to the Commonwealth Fair Work Act stop bullying regime that pretty much applies right across the country, except to various public services that have effectively opted out. The constitutional underpins are quite complex. I won't bore you with that. That's not the purpose of this session. The purpose of this session is to tell you what we've learned from the Fair Work Act Commonwealth regime, because the test is so similar, the definitions are so similar. How's it been interpreted to apply? It's sort of common sense stuff. I think you'll find this helpful. So what does the Fair Work Act scheme kind of, what are the core elements? Let's go through this, but I might just start with a statistic, and just to let you know in terms of prevalence. For last year, if you look at the Fair Work Commission's annual report, there were 751 applications for stop bullying orders made, and only about 10% of those applications resulted in an order being made. So it's a giant funnel of grievance, leading to very few stop bullying orders actually being made, and for reasons that might become obvious when you actually unpack what that definition means. You can see why a lot might go in, but very little is coming out. So the core elements of the federal stop bullying regime are that a worker who's bullied at work may apply for an order. As I said, I won't bore you with the constitutional issues, but it applies to workers. If they're bullied at work, they can apply for an order. Now, they use a definition of bullying that's very similar to what I just talked to you about. Bullying can occur by an individual or a group of individuals. It's about repeatedly behaving unreasonably towards the worker that creates a risk to health and safety, and it doesn't include reasonable management action carried out in a reasonable manner. Sound familiar, right? It's exactly what very, very similar to what the New South Wales State Award has got. So let's just think about that for a minute. What is repeated unreasonable behaviour by an individual or a group of individuals? This is what we've learnt from the Fair Work Commission. There has to be an element of repetition. So one-off alleged bullying is not going to cut it. It has to be persistent, unreasonable behaviour. The same specific behaviour does not have to be repeated. So there might be nuances on the way one bullies. It might start off with deluging with emails and then segue into pestering in person or whatever. It doesn't have to be a repetition of the exact same behaviour, but there has to be an element of repetition before the Fair Work Commission has seen fit to intervene, and that requirement of repetition is restated in your award provisions. I've written the case there for those of you who ever need to look it up. So that's repeated behaviour. Unreasonable behaviour, what's that? By definition, it's what we call it's an objective test. What would a reasonable person see as unreasonable having regard to the circumstances? So it's not a subjective test. Just because I feel bullied, my subjective feeling is that that is unreasonable and I feel bullied and harassed, that doesn't make it so at law. It has to be that a reasonable person looking on would see, would frankly validate my subjective feeling of being bullied. Okay, so you know we all know that in HR we get people of varying levels of fortitude, and some people's perception of what is reasonable is really quite different to somebody else's. Fear not, it's an objective test. So it has to be objectively unreasonable before we've got a problem. And finally, in the definition, it's worth just noting that bullying behaviour must be directed towards the employee who's complaining of it. So it must be towards them, and that's also in your New South Wales award. It's not enough that the bullying behaviour is simply in the same workplace. So this is designed to pick up the sort of, Good Samaritan or whistleblower type person who's not personally bullied, but I'm just letting you know somebody else is, who doesn't seem to have an issue with it. There's a whole lot of things you might want to do with that, but that employee won't be directed at the person reporting it as such is not being bullied themselves. They're reporting somebody else's. So there's that element of bullying directed towards somebody. Or even, so there's a lot I could say about that, but we'll just, in the interest of time, I just wanted to flag that for the minute. So I said to you, I thought I might just tell you some examples of bullying that aren't quite so obvious. There's all the obvious ones that, as I said, is in your award. That list is not exhaustive. There's making vexatious allegations can be bullying. We see that, don't we? Repeated wearing colleagues down by repeated complaints that have no substance. that could be bullying. So there's a bit of space there for, you know, think about being creative here. Obviously spreading rude or inaccurate rumours, conducting an investigation in a grossly unfair manner. I kind of act for public servants who are unhappy about misconduct investigations. When I'm not acting for the employer, I'm acting for the employee. It can be bullying. You can be bullied through the investigation process, right? You can be suspended unnecessarily. Those sort of, you know, silly decisions about discipline can be the subject of bullying. There's a case there that you might want to have a look at if that's relevant. So the definition of bullying, as I said, repeated unreasonable behaviour. That the second element is it has to create a risk to health and safety. Now, what's that mean? You picked up that test in New South Wales. You don't actually have to, or at least federally, proof of actual harm is not required. It just has to be the chance or the possibility of creating a risk to health and safety. And can I say, in my practice, I've never had an application before the Fair Work Commission where this limb has been challenged. You really just need to lead some evidence from the complainant that they feel distressed. Obviously, a medical certificate would help, but doesn't strictly seem to be a subject of contention. It's almost accepted that bullying, being bullied at work, will create a risk to health and safety, and that's enough. They almost take judicial notice of it. So it's not a limb to get too worked up about. Sorry, we've got a bit of background noise there. I hope that's not too distracting for you. It's a COVID time, aren't they? So I wanted to just, I'm going to take a break in a minute, but I just wanted to unpack this definition of what is reasonable management action carried out in a reasonable manner. Because that which is reasonable management action carried out in a reasonable manner is not bullying. And you know, as I said, people's perception of bullying is really quite varied. Some discipline around it doesn't hurt, and both the Award and the Fair Work Act are trying to help exclude from the definition of bullying reasonable management action, providing it's done reasonably. So, just to repeat what I said earlier, there's 3 limbs to that. Firstly, it has to be management action. So, what does that mean? There was a bit of debate about that. You'd be familiar in the workers' comp space. There's always a bit of a fight about the reasonable administrative action exemption to workers' comp claims. That's not getting much traction at a Commonwealth level. So most action will be management action. It has to be reasonable. And the reasonable test, the objective reasonable assessment test that I referred to before, is the test that will apply. And your reasonable management action, say for example, performance management, has to be carried out in a reasonable manner. Now, what does that mean? Again, it's an objective test. If we run with the performance management example, you know, if you're going to performance manage and the discussion's getting a bit ugly, then, you know, perhaps leaving the door open and engaging in heated discussion might be unreasonable by contemporary standards. So it's about thinking about carrying it out in a reasonable way. Now, it's a really interesting point to note, and that the test is reasonableness. It's not perfection. So managers don't have to be perfect. The test is not whether they have to have been unreasonable before it's bullying. And the fact that a decision could have been made in a more reasonable or a more acceptable manner is not necessarily unreasonable. The Fair Work Commission's acknowledged that there's a range of options often for tackling a problem, and the employee's preference as to how that happens. The fact that the management takes a different view doesn't automatically mean, even if it's a better view, it doesn't mean it's necessarily unreasonable. So there's a slight difference there. I think it's worth bearing that in mind. So I'm just skipping a little bit to wrap up the Commonwealth core elements. Bullying providing they're at work, then it's bullying there's jurisdiction over bullying and you've used the same test at New South Wales level. It's at work, not at a workplace. So the fact that you're working from home or you're working, you're travelling for work or something is potentially you could be bullied there. That has particular application, of course, in social media, bullying via social media. It doesn't matter if the person made the offensive posts from their home computer. If it was accessed at work, which could include, say, a meal break, it's within jurisdiction. Strictly speaking, the test is at work is any place where you're performing duties or you're in some other activity that's authorised or permitted by the employer. So there's, as I said, there's a fair bit of jurisprudence around that that will come your way once this jurisdiction gets up, I suspect. And finally, I guess it's worth knowing, just focusing a little bit on this stop bullying jurisdiction. What does it do? What do you get out of it? Do you get cash? No. You get the legislation and your award says you'll get any order that's appropriate to prevent bullying in the future. It's a preventative jurisdiction. It's not about compensation and it's not about punishment. So employees that are after a bit of money are barking up the wrong tree going in this jurisdiction, and it may be one reason why the floodgates on applications for stop bullying at federal level didn't open as widely as they were worried that it might. So there's no cash in it as such. This is for workers who are genuinely bullied at work, in accordance with a proper test, then at a Commonwealth level, they will make an order, orders that are appropriate to prevent the bullying down the track. Now, what they look like in practice, a stop bullying order, they look a little bit like, I don't know if any of you have had a dip into the family law or domestic violence scene, but you may have heard of an AVO, an apprehended violence order, where husband and wife are not to cross paths at certain points, and the order of the court is that dad will keep away from mum, they'll pick up the kid at school at this time, and so on and so forth. It's quite prescriptive about an order that's designed to minimise contact or domestic violence. Similarly, in stop bullying, the orders that come out will be that if there is bullying, and then what is it going to take to stop that bullying continuing? Is it that perhaps these people can't work in the same workspace or the same time, or can't be accompanied, perhaps can't occupy the tea room at the same time, or it really gets down to that level of minutiae, as it were, these stop bullying orders that ensue. It may be that we've seen stop bullying orders that come out and say, that the parties are not to arrive at work at the same time, that this person has to arrive 30 minutes before that person because there's abuse occurring in the car park or some such, or bullying or whatnot. So it's if you think like that, that's the kind of orders that are ensuing. Interestingly, you can only make an order, the Fair Work Commission can only make an order if there's a risk that the bullying behaviour will continue. There's been a huge handbrake on floodgates opening, because if somebody's quit, then they're not at risk of bullying continuing, right? Either the perpetrator or the victim. If either of them quit, then there's no risk of ongoing bullying, right? Because the problem's gone. So there's no jurisdiction there. So this has got nothing to do with terminations or exits. And if those things are in the mix, this is not the right way for an applicant to go, and a respondent can defend it accordingly. So it's worth just thinking about that, because you've got the same. You have to be a worker. You have to be at work, yeah? If you've resigned, you're not a worker. You're no longer a worker. So orders must also take into account that the Commission will not become involved and give stop bullying orders, or not meant to, without taking into account other processes. And I want to dip into this because you in New South Wales Local Council, you've got plenty of processes, right, to hit bullying conduct. So I'm going to talk about that in a second. But at least the point is at Commonwealth level, the fact that there might be a dispute resolution procedure or an investigation on foot is something that the Commission takes into account into deciding whether they're going to weigh in and or whether they're going to kind of hold it in abeyance until resolution of those other parallel processes. And finally, at the Commonwealth level, the core element of the scheme is that the Commonwealth will always attempt, and so the Commission will always attempt to conciliate the problem first, and obviously plenty of matters settle well shy of hearing. Only a very few get through to hearing, they settle along the way. How are we going to manage bullying complaints at the moment, right? Let's just have a look. So, as I said at the start there, your culture initiatives that you've been working on, big picture stuff, training, etc., that needs to happen and continue and be documented. As a matter of defending any sort of litigation, it's a good idea, right? So, carry on with that. I suppose I wanted to just point out, just to make it really clear, obviously, to the extent you've got bullying complaints concerning your counsellors, we've been talking about the award today. The award applies to employees. It doesn't apply to your counsellors. You've got your code of conduct and your procedures for the administration of the code of conduct and potentially the local government act to manage that. So park that. It's not really the issue is for staff. As far as staff, I think what you need to do is just kind of be cognizant of the fact that a person complaining of bullying, let's call them the victim for the minute. There's a victim and there's a perpetrator. The victim can make a stop bullying application under your new scheme down the track, or they can lodge a grievance under Section 36 at least. But it's just worth turning your mind to the fact that in addition to the victim, there's also the perpetrator. And bullying, of course, is misconduct if it's misconduct and not okay under your code of conduct, right? So it's possible, isn't it, that in resolving a victim's complaint or grievance about bullying, you may want to discipline the perpetrator. In which case, then you have to think about the way you're going to manage the disciplinary aspect, because of course you're very regulated in that regard. You've got the discipline provisions of the award, the workplace guidelines, the code and the code procedures to comply with. Okay, hard work, but we can do this. We can unpack it. I do this stuff all the time, but basically it's about trying to cover off all those bases. So I suppose what I want you to think about, if you get a complaint of bullying, you will now have to comply with that grievance dispute procedure of clause 36, where it is alleged, okay, not whether you think it's got legs or whether it's properly articulated or whatever. They can literally just allege bullying, full stop, no further particulars. And that's enough to kick in the grievance procedure on my reading of the award, as obviously we don't know how disputes are going to go in this field because it's too early yet, but at the moment, that's my reading of it. So I just wanted to just remind you, so that grievance dispute clause I was talked about, clause 36, is going to apply. That means they can have their union rep if they want. And of course, you're going to try and resolve it at the lowest possible level, start with the supervisor, and then escalate. As I said, there's nothing new there. What I wanted to tell you in terms of practical, how we're going to handle this, there's this real issue, isn't there, that this whole definition of bullying, the whole subjective, objective, I feel bullied, but somebody thinks it's not bullying, that whole conundrum is a huge problem for HR. And now if we've got a clause that says, well, the minute it's asserted, I've been bullied, you as HR, we have to start triaging it through this clause 36 provisions. How can we put some sort of sensible discipline around this? Clause 36 isn't silly. It says that they have to notify the supervisor in writing of the grievance and the remedies sought. It doesn't say anything about giving particulars or details of the grievance. So I'm being bullied and I want that person sacked. And I put it in writing. Strictly speaking, I've complied. I've notified the supervisor in writing of my grievance. Then, of course, you're going to meet, the supervisor will meet and try to resolve that. Now, this is kind of really obvious. It's sort of complaint management 101. How do you deal with that? The answer is you push back and you ask the employee to go back and particularise what is the bullying. It's not good enough to say somebody's a bully. You need to say how, who, what, where, when, why. Those sort of basic details. Lawyers call them particulars. I find in my practice, I would say it's 90% of the problem that people, inadequate particularisation of the allegations leads to chaos. And one thing you can do as an HR manager to help your counsel is to put some pretty strong guidelines around that, because I can't see the problem unless somebody, I really can't see why, short of to fail to be able to articulate the problem in that level of particularity. If you can't even detail it, you certainly can't prove it, right? So it's just name calling. Without detail, it's just name calling. It's actually potentially defamatory, and it's not okay. So, my suggestion for the day is make sure you get particulars of the problem. So, why is it this person's bully? And particulars of the solution if they haven't already got it. And so I want him gone, okay, let's try and get a little bit more nitty gritty. Well, what specifically is the problem if it were true? Can we have a workaround? Well, you work from the depot and you work from whatever, because ultimately, as I said, that's where the stop bullying orders end up getting to that level of detail anyway. So why not get ahead of the curve and have a conversation in that dispute resolution process of that level of maturity to see if you can't solve the problem efficiently. So that would be something I would suggest. I'm about to finish, but I just wanted to just tackle this. Is my sort of last content slide. One of the questions, of course, as I said, is, well, hang on. So we've got the discipline, we've got the grievance, the new grievance. It's your existing grievance and dispute resolution clause, but we now know it applies to workplace bullying complaints. You're going to have to comply with it. As I said, what happens where it could potentially lead to code of conduct disciplinary provisions? Well, here's my little tip. Where possible, you would try and manage the complaint in tandem with those procedures. So you want to comply with clause 37 at the same time as you're complying with clause 36. It's not that impossible. What does it actually mean? It means you would advise the respondent of the possibility of disciplinary consequences and the right to union representation pretty early, probably at the head of department discussion level, if not earlier, right? Obviously, where there is the disciplinary procedure is invoked, we have to think about procedural fairness. A whole lot, we could talk about that on another day, what it means and how we do it. You were always wise to conduct these interrogations, shall we call them, grievances or disciplinary procedures on a as confidential as possible basis. Do not assure absolute confidentiality because you cannot. It's information circulated on a needs to know basis. And the touchstone for sensible decision making in this pretty you've got a lot of regulation to comply with. There's plenty of traps here, but try and act reasonably. It sounds like a simple thing to do. It's kind of hard, isn't it? Helps if you get a second head on it to give you somebody else's idea of, make sure your idea of reasonableness is what somebody else thinks. That should stand you in good stead to defend any sort of workers' comp discrimination, unfair dismissal, etc., claims that might come out of this down the track. So lastly, I'd say we wanted to, how will this all fit in with any new legislative scheme? As I said, the legislative scheme will work it out. Somebody's going to have to tackle it. Nobody wants to get involved, can I say? The Industrial Relations Commission's probably been pretty shy to date, and they may well keep being shy. Everybody will try and say, oh, will resolve this stop bullying application after you've exhausted the grievance procedure, or after the WHS regulators had a think about it. So there's a fair bit of buck passing there. Usually we get to a point where there's no double ups. Double ups are usually avoided, but you could press for jurisdiction if you need to, and I've done that on occasion.
Thank you very much, Gabrielle. So we have actually had a few questions in our Q&A box.
Yep, social media, love it, don't we? We're going to have another session on that, because what you're hitting on there is the whole out of work, that which is sort of out of work and private spilling over into the workplace. There's a lot of facts there I'd want to dig into, as in, I didn't quite get the full story as to, what was said, who it was circulated to, what's the level of seniority of the employees in question, how obvious is it that we can narrow down the identity of the supervisor, and regardless, is that posts of that nature bringing council into disrepute? They're the kinds of things I would think of. I'd say that getting a little bit close to the wind. The case to look out there is Banerjee and Comcare that went to the High Court last year, so close to that, but said the kinds of questions I'm talking about are the kinds of factors you want to look at to try and answer those questions. Presumably if you're in a small town, that could be kind of bad. Facebook is a scourge, isn't it, for those of us in HR? So that needs to be managed, that situation. Righto, Rachel, I'll leave it there.
Okay, yes, thank you so much,
coming up
Gabrielle.
next.
Yep, really appreciate that, and we're getting thank yous in the chat box as well, so I really appreciate that. So a few extra resources that we just wanted to make you aware of. We, under our HR Breakfast Club website, we do actually podcasts in relation to the webinar that Gabrielle's just done. There is 2 on there that I just wanted to mention to you. One is dealing with difficult complaints with Gabrielle Sullivan and Chris Wheeler. So you can just log on, and we have a tab at the top just for podcasts. There is a second one on there as well, how to stop workplace bullying, which you may find of interest. So hopefully you can just log on in your own time and just listen to those. We have mentioned there as well about the Stop Bullying Bench book, which is on the Fair Work Government's website. We have switched our webinars to quarterly, so our next webinar will be in November. We will give you the exact date shortly, and the calendar invites will be sent out hopefully in October, so we hope you can join us next time, and we will have other guest speakers then. But thank you very much for watching. We really appreciate you joining us.